All right, well, we're going to cover Chapter 9 today. Chapter 9 is going to be the last one of our sort of ones that are going to look at some broader themes before we go to some specific crimes. Chapter 10 will actually start something that will be a little bit more direct for most students, and that will be the homicide statutes. And then we'll go on to other serious crimes, but we still have to lay a little bit more of the groundwork here. We're going to look at, today in Chapter 9, free speech, public order crimes, and the Bill of Rights. We're going to look at some constitutional guarantees. Okay, so again, you've got the learning objectives. We've got 3 of those slides. Not going to go over them except to say that very often when you look back at these, they're going to be the sort of broader topics that are covered. Okay, so jumping in, part of the limitations on regulating speech in the criminal law is going to bump up against the federal Constitution. And specifically, it's going to bump up against the First Amendment to the Constitution. Now, the First Amendment to the Constitution does not just include guarantees about speech. It guarantees freedom of religion, freedom of assembly, which you could argue is speech, press, which you could argue is speech, petitioning the government, which is speech, and of course religion. And religion, of course, will actually bridge, a couple different areas, but I mean there is an argument to be made that religion is a type of speech. It's a declaration of your relationship or lack of relationship with God. So the Constitution does offer protection in all these areas, religion, speech, assembly, press, petitioning, but it is not absolute. And this is also for speech itself. That is, it is limited. Okay, so some kinds of speech we have said, and when I say we have said, what I mean is the courts have interpreted the First Amendment to say, and this is going to be something contentious, obviously now when I'm recording this in September 27, 2020, where 30 or 40 days out from the election, the president has just nominated a potential Supreme Court justice who says that she believes that the Constitution should be interpreted as the founder. She's what's called a textualist or originalist, and she believes that the Constitution should be interpreted as the founders wrote it or understood it. So as they understood it, of course, is going to be some of this case law that was handed down. So this is something that's very much alive today in 2020, 2021, if you're hearing these lectures a little bit later. And as early as the early Republic, the courts have said that this is not an absolute right. So some kinds of speech are not protected. And I think as we start this lecture, here's a quick framework to keep in mind. If you're talking about speech, there's different types of speech. So political speech, such as someone saying, well, I want to support this candidate or I want to support this position, and you're making this in a political area. That type of speech enjoys almost absolute protection. There's really nothing you can do, and I'll give you an example when we get to obscenity in a minute. There's really nothing you can do to limit that type of speech, except in extremely rare circumstances. But moving down from that, you have what I would call private speech, and again, that's largely protected with some exceptions. Then there's business speech or commercial speech, and that has less protections. And then there are some things, which we're going to focus on in here, that fall outside of any protection of the First Amendment. When the government wants to regulate speech, we're looking primarily at 2 things: the content of the speech, what did someone say, and the context of the speech. How did they say it? So there's probably an ability to regulate context more than content. It's easier to regulate how someone says something versus what they said. But again, those points we're going to cover, and they should be a little bit clearer coming up. Okay, so first let's talk about obscenity. Obscenity is really a hard thing to define in many ways. Now, people, again, this is one of those terms that people say, well, that's obscene. Well, obscenity has a kind of more technical legal definition. One of the quirks of our civilization, our society, is that when we're talking about obscenity, we're not talking about just something that disgusts you. For example, no act of violence, unless it has a sexual component, is necessarily obscene. So you can have a picture of someone shooting someone in the head or chopping off their arms or some bloody, revolting picture. That's not obscene. Obscenity refers to sex, a depiction of a sexual act. So the general rules about obscenity is there is no constitutional protection of obscenity under the First Amendment. First of all, if it deals with an explicit sexual act. Second, that it portrays that sexual act or conduct in an offensive way. And third, that it lacks a literary, scientific, or artistic value. So let me look at each one of those just a little bit. So if I just make an oblique reference to a sexual act that is not explicit, so if I use a metaphor, so if I said, hot dogs chasing donuts through the Lincoln Tunnel, I mean, that's kind of an obscure picture. I might be referring to that. The hot dog could be a substitute, a metaphor for a penis. The donut could be a metaphor for a vagina. And that might be a reference then to vaginal intercourse. But it's such a metaphor that it's really not explicit. And it would be hard for someone to say, well, if you say hot dogs and donuts together in a sentence, that's explicit. Now, the second is the sexual conduct has to be patently offensive. And it has to be portrayed as such. So, again, if you're just describing an act of sex, but you're not describing it either explicitly or offensively, then it becomes more difficult to label it as obscene. So the final hurdle to get over is whatever you are describing, talking about, and this can be a picture, it can be an action, because when we talk about speech, we are not just talking about words coming out of people's mouths. We can also talk about a picture that you see, a video, a Snapchat, a tweet. All of those are speech. So does it lack literary, scientific, or artistic value? So you could take something that would be offensive and potentially explicit. So, take the worst part of sexual obscenity. Child molestation would be an example there. There is a famous novel by a man named Nabokov called Lolita, and it is recognized, at least in part, as a classic, but it has, as one of its central themes, the sexual infatuation of an older man for a prepubescent teenage girl. The man's name is Humbert, and believe it or not, and the girl's name is Lolita. You could try to claim, well, this is an obscene novel because it's got some explicit sexual acts in it. It is offensive. But since it has a high degree of literary value, you could not ban it under an obscenity statute. The second thing is, forget for a second the literary value, think about scientific value. If I published a medical textbook, and in the medical textbook, I was trying to teach doctors how to recognize the components of a rape, the physical manifestations of a rape. So you might have pictures or depictions or stories about a rape, And you might say, okay, there is something that is offensive in it. You might say, this rape occurred, here is the description of the rape, here is pictures of the rape victim's genitalia, here are pictures of bruising or vaginal tearing. Now, those are offensive. It is a depiction of a sexual act. However, I would argue it's not necessarily offensive, but I would argue it has great scientific value. So you really couldn't say, well, we're going to ban this textbook because it teaches doctors how to recognize rape. The third one is artistic value, and this would go more towards a depiction. So you could take very famous works of art, like Botticelli's Venus Rising from the Foam, or the Venus de Milo, both of which are depictions of the Greek god Venus, or maybe it's Aphrodite rising from the foam, excuse me. Both of them are depictions of Greek gods, were completed during the Renaissance. They are widely viewed to be the most, or among the most valuable and important paintings and sculptures in human history. The Venus de Milo is actually a good deal earlier. But you could never ban them, even though they are depicting not necessarily a sexual act, but a sexual being, because they have high artistic values. Okay, there is a discussion question here about audio recording, whether, and this is something that really kind of goes beyond some. We got another discussion question coming in a minute, but you should think about this: is who owns the audio recording of the police? Again, right now in 2020 in September, we're having a discussion about a public discussion about the shooting of Breonna Taylor. Okay, should the recordings, and apparently there are some video recordings, initially they were denied they existed, but there are some video recordings afterwards of the shooting. Who should be able to see those? When should you be able to see them? Who owns them? Are they the public's? Are they police? Are they prosecutor? Should they be protected or should they be open? You've got you've got here a link about the free dictionary online, legal definition of obscenity and historical developments of legal definitions. And this goes into a little bit more, and it talks about the ACLU. When you see that abbreviation, by the way, ACLU, that's referring to the American Civil Liberties Union, which is an organization that goes around protecting and promoting constitutional freedoms. Okay, now we're going to move off of speech and talk a little bit more kind of about the context of the speech. And in this one, what about if you're giving a speech and what you're trying to do with the speech is get people mad to do something? So this is speech that is inciting unlawful conduct. One of the ways I like to think about this for my students to make it a little bit easier is to think about other aspects of defenses of law where we look at, say, duress. You can use the defense of duress if there is an immediate physical danger to you. We can use laws against inciting unlawful conduct if there is an immediate danger, an imminent danger, that what is being said will produce violence or unlawful actions. So there are laws. Some of these relate to riots, and again, in late 2020, we're seeing some of this, where if you have speech that is intended to produce unlawful actions, it has no protection. However, okay, it has to be more than I'm discussing this, like, well, maybe we should go downtown tonight and protest and riot the shootings of Jane Doe. If you're merely discussing that, that's not inciting unlawful conduct. But if you were downtown at a public protest that was peaceful at a moment, and you stood up on a soapbox and you said, let's go burn the building down. Well, at that point, that might be inciting because it's you're essentially trying to immediately or imminently create violence. So the two examples there in your book are good, a little bit unrelated to what's going on in America today, but that's why I was trying to give the example of the riots. But if you make a statement to fellow gang members to attack rival gangs if they ever come to our block, that's not inciting violence, because you don't know if that's imminent or if it's going to come right away. But if you get people together in a room and say, let's go burn it down, let's go beat them up, that could be inciting. Okay. What about if a man stands on the corner by your house and speaks in a loud voice about the merits of the KKK? Is this protected? And this, what must you do to break the law? What would you do if what he was saying bothered you? The first thing I think is important is that last one. We can take that and dismiss it pretty easily. Just because something bothers you doesn't mean it is breaking the law. So what must you do to break the law? I really think there was something I read yesterday in the News and Observer, and it talked about a pastor who gave a speech at a political rally saying, he's not a white supremacist, he's not a bad guy. And then he got in his pickup truck and was at a rally screaming white power. Well, that might be somewhat offensive if you're identifying with Nazis or the KKK, but he didn't break the law. He might have shown bad taste, but he didn't break the law. If someone stands up and says, I support the KKK, that's not breaking the law. If he burns a cross on your land, okay, that's an action coupled with it. And while the cross is burning, he's shouting, I'm going to, hang you, I'm going to lynch you. Well, now we've gotten to a point where the context is inciting violence. Public nuisance laws. All states have public nuisance laws, and these are laws limiting how loud something is, nuisance speech, and riot. So obviously, if someone comes to a residential neighborhood at 2 in the morning and starts to play a trombone in front of someone else's house, or a brass band, or loud music, if he's out there playing, I don't care what it is, polka music at 2 in the morning, you can make that illegal. Again, you're not so much regulating the content, you're regulating the context. When is it being done? So laws that limit when, the nuisance speech, which kind of goes with that, and riots are not viewed. But you have to balance free speech and public order. So if you say, we're not going to allow anyone at any time to hold a polka dance party, I know it's a silly example, that might be a violation of free speech. If you said more realistically, we're not going to allow anyone at any time to hold a meeting in support of the KKK, that would be unconstitutional. Again, just because you don't like what people are saying, you can have people that say things that are truly repulsive. You can have people that are white supremacists that say, I believe in white power, and all the bad people that I don't like should go back where they came from. That can be ignorant and offensive, but you have a right to say those things. And it really means we don't inquire into that, the content of what you're saying. But when you couple that with a context of where are you saying it and when are you saying it? Are you saying it at 2 in the morning? Are you saying it with a bullhorn and a megaphone? Well, then there can be a need for public order. We can balance that speech. One of the words that was created, or one of the tests, that was created, was the clear and present danger test. And this is when a judge can regulate speech or can uphold essentially a law on speech. If a speech creates an immediate threat of harm to another, you may suppress it. The example here is if someone shouts, there's a bomb on the plane. That's a criminal act. In all U.S. airports and on planes, it is a crime to say, even jokingly, that there is a bomb present. So years and years and years ago, I worked at the Raleigh-Durham airport. This was way back in the 1980s, before I was a lawyer and I was going through college. And we would have people that would say stupid stuff. They would, and I would be searching their bags, and the guy would go, "Yeah, you're going to find the bomb in the bag." At that point, I had to press a button, and the police came and talked to him. Sometimes he got arrested. You cannot tell jokes about that. And they were so shocked because they would say, "Well, I have a right to say what I want." You do. But the content, okay, is not necessarily what we're regulating. It's the context. Where were you saying it? When were you saying it? Now, the other thing, the next one that can be kind of regulated, and North Carolina has a specific law here called fighting words. Fighting words are words that are likely to incite an immediate breach of the peace. So they can be rude or riotous language where you are trying to provoke violence. So if you come up to someone and you denigrate them and insult them, and you are pushing their buttons, you're talking about their mother or their mama, if you prefer, or if you are just really trying to pick a fight, okay? And North Carolina says words that are likely to incite an immediate violent retaliation. That can be criminal. Again, though, this is context and content. If you use those same words online, it's not fighting words. It has to be an immediate breach of the peace. You got to be in a bar next to someone, on the street next to someone. If you're at home sending this, it's not fighting words. Now, many states say police officers, public officials, have to essentially exercise greater restraint. They have to accept more than a private citizen would be in people talking to them. Okay, so obscene communications in summary. Obscenity is not protected by the First Amendment and may be forbidden. Defining it is the subject of many, many court rulings, some of which really have expanded protections, because what was obscene 100 years ago is not obscene today. But you really have to refer to constitutional law cases. Inciting is urging another person to commit an unlawful act, usually an act of violence. And this can be imminent lawless action, such as riot, and it has to be likely that it's going to produce it. Okay, now we're going to move on to something a little bit different. And this begins to touch more civil side than criminal. And this is defamation. Now, defamation is the broader term. Libel and slander are the specific examples. So, libel is written defamation. Slander is oral defamation. If I write down, defamation is essentially injuring someone's character or reputation by a false statement. Now, by the way, if it's true, that's an absolute defense. If I'm not injuring their character or reputation, it's not an offense. So libel is written. If I write a sentence that says, so there's two candidates running for president by and large right now. There are others. There is Donald J. Trump and there's Joseph Biden. If I write a sentence that says, Donald J. Trump has been divorced, okay, that's not ever going to be subject to defamation because he's been divorced twice. If I write, Donald J. Trump killed a small child, that would be subject to defamation because it's a lie. Now, slander. If I said, we'll pick on Joe Biden here, if I said, Joe Biden will be the oldest person elected president, okay, that is not slander, again, because it's the truth. If, however, I said, Joe Biden set fire to a church just to watch it burn, that's slander because it's false and it's holding up their character reputation to injury. Again, you don't tend to see a lot of this in the criminal law. It's much more handled on the civil side. Okay, now remember when I was talking about speech early on, I said speech is not just the words that come out of my mouth. Speech also really covers quite a number of things. And here we're going to talk about symbolic speech, um, non-verbal speech. Hold on. Okay, I just wanted to check that. I'm sorry. Non-verbal speech is when you do something without using your words and you're trying to convey a idea or belief. So one of the ones that was a big issue a few years ago was burning an American flag. So if you think about the different ways you burn American flags, so let's just use that as our example because I think it's pretty illustrative. Boy Scouts, my son was an Eagle Scout, has a ceremony whereby they take old and tattered flags, and the way you properly dispose of an American flag is you burn them in a respectful ceremony. So now think about this. You have Boy Scouts gathered around a fire burning a flag. Now they are doing that out of respect. Then you might have, say, a protester. You often see other countries, for example, that will take American flags when they're mad at America and they will burn them. So they're not burning the flags let's suppose this happens in North Korea. So there is a protest there and they're burning an American flag in protest in Pyongyang, the capital of North Korea. They're not burning it in a respectful way like the Boy Scouts are. They are burning it in an offensive way. So when we talk about regulating speech, one of the things you have to ask yourself is, well, what are you trying to convey here? So symbolic speech are actions that we recognize may be speech, and it may or may not be protected. It just depends on the context of the speech. So the example here your book gives, wearing a ninja mask to frighten people into leaving a city council meeting is not protected. Wearing it as a way to protest agitation is protected. Symbolic speech that is disruptive can be regulated. So this really gets back to the symbolic speech about the flag. The Supreme Court of the United States, and there was a lot of opposition to this, the Supreme Court of the United States has said that statutes that make the burning or defilement of a U.S. flag a crime are protected. You can't criminalize it. But then you can have things like cross burnings. So it is a symbolic act. If you had a statute that was very broad, that said no one can ever burn an American flag, no one can ever burn a cross, both of those would be unconstitutional. If you had one that was unrelated to the content of it, so like if you said it's illegal to burn an American flag where there's a danger of causing a forest fire, perfectly okay. If you said it's illegal to burn a cross on someone else's land or for the purposes of intimidating them, perfectly okay. But if you said you can't burn a cross on your own land because you want to get together with with the other idiots that are in the KKK, then that would be too broad. Okay, why is it a hot issue? I mean, this is something that that really is how people react to it. What makes people mad if you're burning a flag? And I'll let you look at that discussion question separately. Okay, now let's talk about the threat of violence. Because remember, content, context. If you are seriously threatening to inflict bodily harm, that is often a criminal act. And you have no constitutional protection. So if I come up to you and I say, I'm going to take this axe and cut off your arm, and I'm standing there with an axe, that's a threat. It's a speech, okay? There is no constitutional protection of that speech. So it has to be a real threat. I think you have to look at the context of it. I think you have to look at the time of it. Now, some threats that you see, threats against public officials, if I call up and I say, I'm going to kill the senator, I'm going to kill the governor, I'm going to kill the president. Threats by school children against teachers, terrorist threats, violations of restraining orders, or threats that use the U.S. mail, the telephone, the internet, or email to threaten another person, all those can be looked at as true threats. But it's got to be putting someone in fear of bodily harm. If it is clearly a joke, if you're taking it out of context, if a reasonable person wouldn't believe that you meant to carry it through, then it's not going to be a threat. Loud noise or nuisance speech. It's clear that the government has a substantial interest in protecting its citizens from unwelcome noises. So there have been numerous cases that upheld the idea that city ordinances regulating private parties are okay, but, there's a big but here, they can't be so broad that they strike down all ability to exercise First Amendment rights. So if you say you can never have a parade, you can never have a meeting, that would be overbroad. But if you say you can't have a loud meeting between the hours of midnight and 6 a.m., I think the courts would uphold something like that. Often we get to the issue here of, well, what about public and private places? And again, this goes to context. Private places are much more likely to be able by themselves to exclude expression. So let's use a practical example here in Raleigh, North Carolina. Let's suppose we have Crabtree Valley Mall. Crabtree Valley Mall is a private place. It's owned by a corporation, I assume. And can Crabtree Valley Mall put limits on what people can say inside Crabtree Valley Mall? And the answer there is yes. And they can probably place more limits than can the city of Raleigh place limits on what can be said in the Fayetteville Street Mall. Of course, it's largely gone now, but let's just suppose the grounds of the U.S., the North Carolina Capitol. Now, what the courts have said is the right of expression in public places is not absolute. We can look at the time you're doing it. We can look at what you're doing. Is it a threat to public safety, which would really mean, like, is there a threat of violence or injury? So we've got kind of a balancing test here. The right of the people to exercise the First Amendment and the need for public order. And you know, this is something that is argued over and over and over again in American history. So you can go back to I'm reading a book right now on Henry Clay, who was an important senator in the United States in the 1840s, 50s, 60s, although dead by the 1860s. And one of the debates was, would Congress accept anti-slavery petitions? Because many people in the American South said, you shouldn't even be looking at these. And other people in the North said, well, you have a constitutional right, in fact, a constitutional duty, because you have the right to petition your government for redress of grievances. And so if we were arguing about this in the 1850s, can you petition Congress, can you exercise free speech, it shouldn't come as a surprise to you that we're still having these same debates in 2020. You have to balance the need for personal property, personal rights, the rights of other people, public order, versus the ability to express yourself. All right, obstruction of law. There are a number of ways that you can commit this offense. One, failure to identify yourself when there's a legal obligation to do so. If I'm walking down the street, there's no crime been committed, a police officer is simply bored. If he testifies, I had no reason to believe that John Doe was guilty of anything, but I wanted to know who he was. And I came up to him and I said, give me your ID, who are you? and I say, no, I didn't do anything, there's no crime, there's no reason, I'm going to go about my way, officer, I'm sorry I'm late for an appointment. If the officer arrests me, that's a violation. However, if, the next example is a bit better, there's a witness to a felony or a serious accident, and a police officer comes up and says, you were present at the scene of the crime, what's your name? And you say, I don't want to give a name. Well, the police officer actually can compel you. If you make a false statement or provide false information to an officer who's investigating, that's obstruction of justice. So someone comes up to you, there's just been a bank robbery, the bad guys were driving east. Cop comes up to you and says, have you seen the bank robbers? And you say, yeah, they were going west. It's a false statement, obstruction of justice. Tampering with a witness, with a victim, or an informant, those are all federal crimes. Giving false information to an officer that obstructs a computer record search, obstruction of a crime scene, or failure to identify a known offender. All of those. Now, we are getting close on some of those to constitutional offenses. Public nuisance as civil or criminal offenses. Under common law, a public nuisance was a civil offense. Today, we tend to use civil law. Remember, civil law is more we sue people. Public nuisance laws have been used to tear down things like crack houses, orders against prostitutes, seize property by slumlords. This is a civil action. You don't have as many constitutional protections civilly. Going back to Crabtree Valley Mall, if they want to regulate speech inside Crabtree Valley Mall, they can do things that the city of Raleigh could never do. Stalking. Now, in North Carolina, let's use the standard North Carolina domestic violence protection order. It's called a 50B. Very often, men and women have relationships with other people, domestic relationships that eventually deteriorate to a situation where they are being threatened or feel they're being threatened. So they could go and get a protective order. This is called, as I said, a 50B. What happens when I get a 50B? Well, it says something like, okay, Jane Doe cannot come within 50 feet of me, cannot contact me by phone, cannot send me a text or a Twitter or an email. If they do, that violates the protective order. Now, sometimes there are also additional laws against stalking where you haven't gotten the order yet, but you're engaging in such activity that you would place a reasonable person in fear of injury. So if I'm waiting outside the Piggly Wiggly where Jane Doe works every night, and I stare at her in my car, from my car, or I come up to her and I circle her car like a shark, that would be stalking. And you can criminalize that behavior. Crime on city streets. Again, this is kind of a balancing act where we can have anti-cruising laws, which we don't let people drive up and down. We can have truancy arrests. We can have juvenile curfew laws. Laws directed at homeless people a little bit more difficult to enforce. And stalking laws, again, we just talked about those. And most of these are balancing between public safety and individual rights. But clearly there can be more laws against more laws favoring public safety versus individual rights. All right, let's talk about guns. And this is more a Second Amendment issue than a First Amendment issue. But the right to bear arms is an individual right guaranteed in the Constitution, federal Constitution. The government may not completely outlaw ownership, but may regulate it. So what are some things you can regulate? Well, you can say people under X age cannot own a firearm, or people convicted of a felony cannot own a firearm. You can control certain types of firearms, their manufacture, their sale, their shipment. For example, fully automatic machine guns, anti-tank rounds, nuclear weapons. All of those you could make illegal. So we allow some regulation of gun ownership, although less now than in the past. Religion. Now we're back to the First Amendment, leaving the Second Amendment. There is a guarantee of religion, but like the freedom of speech, there are limits. What you believe, again, content, is absolute. You can believe whatever you want religiously. You can believe in a God or not believe in a God. You can believe that God is Jehovah or Allah or Jesus or the flying spaghetti monster. You can believe whatever you like. You cannot make it a crime to believe or not believe in any being. However, actions related to that do not enjoy complete defense. So there is a biblical passage that you can handle serpents if you have faith, and there are certain churches, particularly here in North Carolina, although not many locally, that practice poisonous snake handling. If you wanted to do that in public, could the state regulate it? Sure they could. Child labor. There are some religious sects, the Fundamentalist Latter-day Saints, they're an offshoot of the Mormon Church, have been accused of using underage child labor, claiming a constitutional protection. Yes, we can take children as young as 8, 9, 10, and we can make them do hard physical labor because it's part of our religion. And the state can intervene and say no, so long as that's applied not just because of the religion, but everybody. Then you've got things like human sacrifice. Could you, if you were the worshiper of, pick an odd religion, Baal, who was an ancient Phoenician god that required the sacrifice of a firstborn infant on a fire, throw them into a fire, believe it or not. Could you outlaw that? Sure could. What about animal sacrifices? You can outlaw that or regulate it. Now, there are some things that you can outlaw secularly, but you're going to have to allow religiously. So let's go to animal sacrifice. This would be an interesting one. Suppose you have a law that says you can't have a slaughterhouse, place where you kill animals, within the confines of the incorporated city. So you said any slaughterhouse has to be outside. But you had a religion that practiced the ritualistic killing of an animal. So you could see this in ancient Judaism, where they sacrificed goats or sheep. You can see it in some of the Caribbean religions, inaccurately called the voodoo, where they would sacrifice things like animals. Santa Maria is the major one. That they could probably have a church. So suppose you had a fundamentalist, I don't think there is such a thing, but a fundamentalist throwback Jewish religion that said, well, we want to have a temple in the city where we can have the private sacrifice of a goat. And the city might say, well, we have a law against slaughter. And they say, yeah, but this isn't truly slaughter, this is a sacrifice. That might be okay. They might win a lawsuit about that. But it depends, I think, in many ways, how mainstream the belief is, how many people practice it, is it a sincere belief. If you just say, well, I want to do peyote, or I want to, because that's part of my religion, that's not going to get you too far. But there have been cases where American Indian tribes, Amerids, had sued because they could reasonably demonstrate that the ingestion of peyote or the ingestion of certain substances that were legal is part of their religious ceremony, that at least the courts would entertain those arguments. Privacy, last thing we'll talk about. Now, the Constitution does not explicitly say you have a fundamental right of privacy. However, it is implied. So sometimes you hear this argument. If you take all the constitutional rights you have, freedom of religion, freedom of speech, freedom of assembly, right to bear arms, due process, substantive due process, procedural due, if you take all those together and you apply them, what they create is a penumbra or penumbra, which is Latin for shadow. It creates a shadow, and that shadow is personal privacy. So the interpretation really is the government cannot pass laws that impinge upon personal liberty unless there is a narrowly restrictive and fundamental purpose for it. So, example, could I read let's take, I don't even know if it's published anymore, but could I read a Playboy magazine in the privacy of my own home? And I think the answer there is sure. But could it be banned on a public bus in Raleigh? And I think the answer there is yes. And that shows you the distinction between public and private a little bit. What you do in your own home is far more likely to be protected than what you do in public. The government has to come up with a very good reason to ban something which is, I would say, not harming someone, but is an expression of a person's desire or liberty if it's being done just in their own home. They have to have a very strong reason to ban it. So if you possess child pornography in home, that could be illegal. But if you were just reading, let's go back to that book I talked about, Nabokov, in your home, you might argue, well, it's a disgusting book, people shouldn't read it, but if you want to read it in your own home, I don't think the government can do anything about it. If it was illustrated and you wanted to read it on a bus, I think the government could have something to say about it. Okay, on that note, we're going to finish up. I hope you enjoyed the lecture, and that's going to be it. You all have a